Hey guys. Hello Thursday. Sanbonani, Dumelang, welcome guys. Thanks for joining. Wipilo, hello, the future jurist. How are you? Welcome, thanks for joining. Patrick, thanks for joining. Tabang, thank you for joining as well. Risang, I see you. Candy, welcome. So it's 12 of us. Leadership Clement has just joined. Hey Mika. Lebza, hi. Funeral policy issue. Hey Snay, how are you? Welcome. Zweli, I see you. Hey Beverly. I hope we won't have technological issues today, and you will see me as I appear, and I really hope that Instagram is not going to deal with me like it did last week. There you go. Rar.
I'm
well. What's a fella Instagram suddenly just cut me all over. I need to fix this.
Yeah, can you see me properly?
I can see you. Just hold on. Just I don't know what's this thing doing. Can you see me?
Yeah, I can.
Loud and face everything.
Yeah, I see you quite well.
Okay, because people were complaining last week, so I've literally adjusted the settings, and I've done my part. Is this better?
Yeah, I think it's fine.
All right, let's hear from the masses. Masses, is this Marumoagae?
What are you trying to say, my man?
All I'm saying is we both got haircuts, and it's a good thing. It shows that spring is spring.
Sprung.
Yeah. Barry, you are a little blurry, Clement.
Me?
Yeah.
I'm not sure what I can do.
Just move on.
Move the light. Perhaps maybe that might assist.
Who's blurry? Someone says it's blurry. Nomhle.
Nah, it's worse. It's gonna be worse.
Okay, Barry Clems is fuzzy. Let's see. Maybe log off Clems and then and log on again.
Okay.
Yeah. Hope you guys had a good week, and it was filled with good news and good things. I really do hope that was the case. August is done. This week, this time will be in September. And if you're still waiting for those good news, I do hope that they come sooner than later. Clement has just sent a live request. Let me just accept it.
How is it like?
This is perfect. I see you loud and hear you loud and clear. I see you clearly. Can you see me? Am I okay?
I see you. You are picture perfect, man. But I think it's not much about how we look like. I mean, it's much about what we are saying.
The content. Absolutely. But you know how it is sometimes, you know.
I understand social media and the artwork, like everything has to be on point. You know, I understand.
Not really, but we try. All right. Thanks, Rara. Thanks for making time. And really appreciate the time that we've spent really in the past 4 weeks, assisting, empowering, and sharing knowledge with people who really are willing to learn and also ask questions. So thank you, and thanks everyone who really is joining now and who's been joining these sessions religiously. And we do appreciate your views, and we will continue to do so. Today it's the final day or week for the family law session, and we'll be looking at with a pension fund, pension interest.
Pension interest and living annuities.
Clement. So it's pension interest and living annuities. You'll recall from the first week we dealt with family law in general. We got on and we spoke about divorce. We moved and we spoke about customary law and cohabitation and other related aspects. So today it's the end of it where we bring everything together and also just talk about what ordinarily is the case on pension funds, for example, and pension interest. And also, you know, for some of us, the distinction sometimes is blurry. What is a provident fund? What is a pension fund? What happens? What are the rules and stuff like that? So we do appreciate the moment and for us to be empowered. And Clement, once again, I do not take your time lightly, nor other people who are viewing this, and we really appreciate your time, sir. And thanks for joining us.
Thank you very much to me. And I think we need to make it worthwhile, given the fact that is the last one. And it was deliberate that I had to suggest that we do this last, because in many instances, you find that this becomes the major issue in relation to some of the divorces that have been instituted in South Africa. And you find that sometimes, you know, like I said when I started, and I'm happy that there might be people who are really familiar with family law who are joining us, and it is really important that they partake in the discussion. And of course, if they hear something that it doesn't go down well with them, and perhaps maybe to them it might be a misrepresentation of what the law is currently. I mean, we are more than happy to have them disagree, and of course we can engage with each other. But most importantly, I just want to reiterate or repeat what I've just what I had said in the previous weeks, that we are not providing expert analysis of anything that we are saying, but a broad overview of some of the issues that are at play in relation to the topics that we are dealing with. So, but yes, we are, and if anyone wants like a direct sort of tailor-made solution to whatever problem that they might be going through, perhaps it is important for them to contact directly so that we can actually look at the specific facts, so that we can actually research the law around that and see as to how we can provide answers. It is really important. It is really important that I just put this up front. In many divorces, you know, family law, especially divorce law, let me not generalize family law, divorce law. Every law firm or every second law firm somehow does these divorces. It is one area of law which I think most of the attorneys think they can just wrap into it and just do it and run with it. And it is sad. It is really sad, because some of the divorces that are being instituted, people's rights in relation to the finances, properties, and in particular the pension fund benefits are not adequately taken into account, or are not adequately pleaded for them to be able to first maybe get a share thereon, or to actually make sure that there is a forfeiture of benefits in relation to these assets. So it is really important that when you are going through a divorce, and some people do these do-it-yourself divorces, whereby you go to a regional court or you go to a high court, and you find that there is a pro forma document that you sign, and it's a fill-in, and the clerk of court will assist you in filling in those. In most instances, people can do those things and everything can be fine. You know, it so happens that when people say, no, we don't want to waste money on lawyers and all those things. I mean, that we can understand. And in some instances, people can do these things themselves and everything can be fine. But the thing is, there are nuances in divorces in relation to property that you need a properly, not necessarily a properly qualified person, because I would think that all the lawyers are properly qualified. But you need somebody with expertise in relation to the interaction of divorce law with property law, with insurance law, and with pension law. And when your papers are drafted in such a way that your rights are adequately taken into account so that your rights can actually be protected. And that is important. And this is the message generally in everything that I'm going to say today, that I want to pass it out there, that people should be very careful when they are going through divorces to ensure that they have people who are well versed in the subject matter. It is really important to do so. Otherwise, you find that you go around, you start paying, but the results are not as they should have been had you been properly assisted. Like, for instance, I will never touch a road accident fund matter. I will never do that, because there are people who are adequately placed to do it. Whenever I receive such an instruction, I pass it on to the guys, because that is not my area of law. Equally so, there is one area of law that I know very well, labor law, but I will never touch it because I don't practice in it. There are, like, to me, for instance, you are a labor law specialist. You are the person who's...
But I definitely would not touch on other things that I don't know. In fact, with family law, really, it's been more of a concept at university, right? And now via these sessions. But if, you know, one has to go back to practice and then get an instruction, I'm not coming there. But talk about retrenchment, talk about dismissals, that's what we can dissect and look at. But I think it's actually important, Clement, on that point before we get in, because what we also see on social media is people complaining about a disservice, right? An attorney having taken a matter and not advising properly, and then you get to find the likes of prescription, for example, having occurred, or client's interest having been fully ventilated. And that comes as a complaint. It's 5 years down the line, and there's nothing that you can do. You know, and what it means is this person has really brought the profession into disrepute, and we all get this name that lawyers are scumbags and stuff like that. So at first, research, find out, ask questions. I think it's very important to ask questions so that whenever you feel that there's a disservice, you can at least start shopping around. And I think we also do acknowledge that the right to access to legal representation is quite an important one, but it only applies to a certain extent to a few. If you have money and you have, you know, access, you're most likely going to be able to ventilate the rights. And that's why the activism and the law reform aspect of it needs to come out, and it needs to happen. And that's the work that we should also be focusing on as activists, as academics, and stuff like that. But I think it's a well made out point, Clement. So as we ordinarily do, we firstly go through conceptual aspects, and Clement does a presentation and just gives us some concepts. And then the next 30 minutes or 20 minutes thereof is when you then come in as a viewer. You then ask questions, we answer your questions. If you want to ask questions, for example, and want to do so anonymously, you can just use the question tab there. I won't show it on the screen, but I'll note it and then put it to Clement. But if you want to ask questions on the live, and you want to also empower people and share, please do so. But we would appreciate an engagement. So, Clement, over to you. You can start just giving us a high-level conceptual aspects, and then we can get to the live discussion and the Q&A.
Thank you very much, Tumi. You know, to start with, when somebody is instituting a divorce or instructing an attorney to institute a divorce or instructing an attorney to defend a divorce. Of course, there will be a consultation wherein all the facts relating to the matter will be ventilated. And of course, the attorney will be advised on some of the matters that really are clouding that kind of an instruction. And it is important to realize that as we started, we said that people can marry in community of property, people can marry out of community of property, and people can marry out of community of property with the application of the accrual system. Right. Currently, we have the interaction between divorce law or family law, if you like, and pension law. There are two aspects where these areas of law meet directly. Yeah. It is in relation to the pension interest, and it is in relation to maintenance. I'll get to maintenance in a bit. Yeah. In relation to pension interest is for all those. Okay, before I start that, let's start with what is a pension fund, because there are incorrectly, let me just put it this, incorrectly, we can say that there are two kinds or three kinds of pension funds. Okay. Incorrectly, we can say that we have a provident fund. A provident fund is a kind of a retirement fund savings scheme, which is employment-based, wherein a member contributes for a period of time. And the member, when he or she exits the fund, be it through dismissal, retrenchment, resignation, or even retirement, the member is eligible to receive the entire benefit as a lump sum. In other words, you don't leave anything in the fund. There's no annuity or periodic payment that will be paid thereafter. You get everything. That is a provident fund. A pension fund, it is the same scheme, but the difference is at the end, when you exit the fund, you can only commute or take 1/3 of the benefit, and the 2/3 of the benefit will be used to pay you a monthly annuity, or what people call a monthly pension. Like, for instance, take a police official who retires. That police official who was a member of the Government Employees Pension Fund, you find that at the time of retirement, he will continue to receive a monthly salary, which is to some extent similar or close to what he used to earn. If he used to earn 16,000, he might get 12, 13,000. So it is an income replacement mechanism of some sort. Yeah. So that is the pension fund. Then you have a pension fund as well. It is occupation based. You can only get that when you are part or when you are employed somewhere. Then you have what they call a retirement annuity fund. A retirement annuity fund is a type of a pension fund which is not employment based. In other words, you can actually
pick it up,
save with this vehicle. Yes. You can go to any a big financial institution like ABSA, like Momentum, like Alexandra Forbes, Old Mutual, all those. They have their own retirement annuity funds. So you will be able to contribute over a period of time. Most of them, you contribute up until you are 55. But there are those that I've just recently learned that there are those that can actually take you all the way up until 60. So you can negotiate as to how much you want to contribute. So you don't have to be employed anyway for you to be part of that particular scheme. So basically, those are the three. And incorrectly, so we can say that. Of course, there are others, but I don't want to complicate the debate because we have preservation funds, we have deferred benefit funds, we have all those. So for the purposes of this discussion, I don't want to get into those. Let's just take it as if it's a fact that there are only three. Because the principles are the same in relation to all of them in the context of divorce. Yes. So now you find that in South Africa, we have a fragmented regulation of pension fund, as it were. In other words, there are pension funds that are, various pension funds or different pension funds are regulated by different legislation. Like, for instance, if you are in the private sector, the Pension Funds Act will be applicable. With some people who are in the public sector, like, for instance, your nurses, your police officials, those, you find that there is a particular government employee pension fund law which deals with their pension funds. ESCOM people, not ESCOM, Transnet people, they have their own. Telcom and post office people, they have their own. So you find that it is important for your attorney to know which legislation actually governs the kind of pension that your partner or yourself is actually a member of. So that is important, first and foremost, which pension legislation is applicable to a particular divorce. That's why when I said, this is a highly technical area, it needs somebody who really understands. Because I have seen people post the divorce, come into my firm and say, look, things have went bad and all those things. And when I look, it's a mess. And the Pension Funds Act was applicable, was used. So you're using the wrong statute to assist the person, because you know, I mean, it is deceiving. Pension Fund Act, definitely, everyone who has a pension must be regulated under that particular legislation. So it's important that you really understand what is going on when you're dealing with these issues. Now, let's put pension fund and its principles and its laws aside. When you come to the Divorce Act, Section 7, subsection 7 and 8 deal. Oh, before we go there, the definitions of the definition section or portion that is included in the Divorce Act gives the definition of what a pension interest is. In other words, if you are having a pension fund, then the pension fund, you are contributing on a monthly basis. And when you're contributing, you are building a portfolio over time. So at a certain time, the trustees of a pension fund will invest your contributions, and as and when good returns come, your benefit grows exponentially. So at the time when you exit the fund, if you are married, then we look at how are you married, so we can see the rights, if any, that the other person has in relation to your pension benefits. Now, you find that there are different benefits in pension funds. You have you have withdrawal benefits, you have funeral benefits, you have disability benefits, and so forth and so on. But at the time you are married, there is, because there are different exit events from that fund: resignation, dismissal, and whatever. So divorce, it is a special exit event which does not lead to the member exiting the fund, which enables the fund to provide the non-member who is married to the member the portion of the benefit that is held in the fund. In other words, they can disinvest it so that they can actually make payment to the non-member spouse. So when you look at the Divorce Act, Section 1 deals with what we call the pension interest, and it defines what a pension interest is. And it defines a pension interest in relation to pension funds and provident funds. The definition is the same. And it defines the pension interest in relation to the retirement annuity fund, which is a different definition. So there are two parts to it. But basically, when you look at both of them, basically, a really paraphrased definition of this thing is the amount that the member will be eligible to receive had the member resigned, was dismissed, was retrenched, or retired. So that amount, that if the member was actually exiting the fund, would be eligible to receive, that amount is a pension interest. And the non-member spouse will be given a portion of that amount. So now, when we leave the definition of the pension interest, then we go to Section 7.7 and Section 7.8. Those provisions are important because Section 7.7 says the pension interest as defined in the Divorce Act is deemed, and they use this word, deemed, to be an asset in the member's interest. But when you look at the Act, it uses the word his, like it is deemed to be an asset in his estate. And his must be interpreted to mean his and hers.
Yeah.
So it's not discriminatory at all. It is just, it incorporates both. That's how it is understood.
Yeah.
Now, once the pension interest has been deemed to be an asset in the member's estate, if now we look at how the member has been married, if the member is married in community of property, that means that pension interest, by virtue of being an asset that belongs to, remember when we started, we said, if you have a TV and you have whatever, when you join hands, all those things, they become one. So because now there is this financial asset that you have, or that has been deemed to be part of your estate, it will automatically be deemed to be part of the joint estate. Therefore, the non-member spouse will derive a right to make sure that he or she benefits from that pension trust. So he or she will be a co-owner in undivided shares of the entire benefit. Now, it will be up to you how you negotiate as to what portion of that pension interest should be payable to the non-member spouse. So that is really important. That is really important. It is not an automatic, as people will always say, like, no, I will get 50% of his pension interest. No, you are actually a co-owner of the entire 100%. So at the time of divorce, it needs to be quantified as to how much you will get, because you need to quantify how much you are going to get so that the amount that is remaining will be invested again for the benefit of the member. So you are not going to, it's not disinvested so that it can be shared between the two of you. In other words, the member will not receive anything at that time. Only the non-member spouse will receive something, and the fund will continue to invest because the member is still employed in that particular pension fund. So it is important to get those quite right. So now, yes, to me.
Yeah, I think it's a very important one and key. So if I am still employed and I happen to go through a divorce, whatever, if I have 500,000, that's then what's going to form part of the estate for purposes of divorce, and will then be shared depending on, as you said, and depending on how it's negotiated, I may well either, depending on that, 250 or something like that. But whatever the remainder, I will be left with it and still continue with the fund for as long as I'm employed.
Definitely to me, because what will happen is the fact that you are being divorced, it does not mean that you are going, as a member of the fund, you are going to get your benefit. It simply means that this is a legislative avenue that has been created to benefit the non-member spouse. While the dismissal, retrenchment, whatever means you're going to get your money as a member, divorce is a special one for the non-member spouse, not the member.
Right. Okay.
That is really important.
Yeah.
So now, when we move to Section 7, subsection 8 of the Divorce Act, now it clearly provides that the court, in other words, the divorce court that will order the decree of divorce, must determine and order the pension fund to pay the non-member spouse. In other words, what happens now is, and now I need you guys to be with me on this one because it gets technical, and I think a lot of people are getting it wrong, even the courts, and it is really important to really understand this. One, a non-member spouse, by virtue of divorce, is entitled. It is an entitlement to an extent of being a right. Is entitled to a portion of the pension interest. There is a case in the Supreme Court of Appeal that has confirmed this. Ndaba versus Ndaba has confirmed that the member is entitled to it. Now, the law is such a mess that even when you are entitled to something, if the court will not make an order that the pension fund of the member should pay a particular amount or figure to the non-member spouse, the fund will refuse to pay the non-member spouse their portion of the benefit. It happens every day, where you take an order, you take it to that says division of the joint estate, doesn't say anything about the pension interest. You take it to the pension fund. When you get there, they say, Section 7(8) says that we should be, even though they know that the member is their member, they know the member is married, and you are showing them that because you know of the marriage, here is the divorce, and the divorce says division of the joint estate. Division of joint estate means division of the assets in the joint estate, and inherent in that, it implicitly also talks about the pension benefit. So the law as it stands now, and we are fighting to actually get the law changed so that it can represent the correct version of how things should be. What happens now is, if you don't have an order, you are forced to go back to court to try to vary the order so that it can state the pension fund. But herein lies the problem. Depending on which attorney you went to, it might be that in the particulars of claim, there was no allegation relating to the pension interest. In other words, the pension interest was not pleaded. And if you do not plead something, you cannot request it. So it becomes a challenge in that sense. If you don't, even with the assets of the house, when you are saying you want to a share of the house, you're going to say there's one immovable property within the joint estate situated at that address. You mention those things so the court can have a sense of all the assets in the estate. So now, if you went to somebody and this person did not take this into account and made sure that he put those overments in, but most importantly, as part of the prayers, he says 50% of the pension interest or 20% of the pension interest must go to this person. You're not going to get far. You are not going to get far, because the law as it stands now is the court must order the pension fund to pay a particular amount or percentage of the pension interest. But it doesn't end there. Also, not only do you have to identify the actual pension fund, the court must order the fund to pay a particular figure. Because if it doesn't pay the particular figure, they will tell you that, look, we don't know how much you should pay. The court did not tell us. So it is important for attorneys who are listening that, one, you get the name of the pension fund concerned. No one, the member has a right to the non-member spouse has a right to information. So it is important you get the proper name of the pension fund so that you can include in your papers if you don't want stress. But secondly, you need to put a figure or a percentage that must be paid to the non-member spouse. Otherwise, pension funds will not at all pay. But I argue that that position is wrong. If you are entitled to something, you can actually get, you should get. But that remains an academic opinion that we are trying to influence the law. But the law currently is Section 7, Section 8 must be complied with. And again, when you go to the attorney, with those pension funds that fall within the Pension Funds Act, Section 37D4 of the Pension Funds Act that deals with these things. It gives you two things. Is the name of the pension fund must be named or must be identifiable. So sometimes, if it's not named, you can actually argue that it's identifiable. So you just need to say, you guys know that this guy is your member, and this guy's name appears in the particulars of claim. Not only that, in the divorce decree. So by implication, by the fact that his name appears there, we are identifying this person. But that can be an argument that you can make. But you don't want to get to that. You want to ensure that you get everything right in accordance with the law as it is, so that your client does not have to incur unnecessary expenses with all the interlocutory applications that you want to bring, that you force people to pay. So it is really important to ensure that when you go to consult with your attorney, you need to make sure that you have the name. It is not that difficult to get a name. One, you can get the name from the salary advice of your partner. If you have them, you can have it there. But if you don't have them, you can actually assist your attorney to get them, because attorney can call around, but you need to tell your attorney where your partner works and all those things, so that it can be easier for them to get that information. So that information, as a non-member spouse, you are entitled to get, so that you can actually get your, and if they are refusing, you can actually compel them, bring an application to compel them to give the information, because you don't want to put wrong things there, and you need to come back to court and vary and all those things. Well, you can actually move on with your life. So that is as much as pension interests are concerned. It is important, because most of the times the pension interest is the largest asset in the people's estate. So it's important that everything in relation to it is done correctly. And the Divorce Act applies to all the pension funds, irrespective of which legislation actually regulates them. It applies equally to the Government Employees Pension Fund, the Pension Funds Act, and all those. So when you are divorcing, Divorce Act is a general law that deals with divorce in South Africa. But the nuances will be dealt with by those specific legislation. But it's important that you understand the workings of the Divorce Act in order to assist your client adequately. So that is it basically in relation to the pension interest and divorce. I just want to now move. I don't know. Do you want to add something, or should I move to living annuities?
I think you can move to living annuities. There's just a few questions that have come through, and we'll deal with those as we go along. But you can just move to living annuities and just take us through that.
Now, what happens is when a person retires, you find that the rules of your pension fund will say you are entitled to purchase an annuity when you exit the fund. Most rules are, I'm just paraphrasing, most rules are to that extent. You can actually purchase an annuity with an approved institution, a third party. So what normally happens is most of the pension funds are administered by insurance companies. That's why there is this blurring between the two areas of law, and they are quite distinct. In actual fact, the principles are quite different. The principles of pension law are quite different from the principles of insurance law. But for some reason, pension funds in most instances are actually driven by insurance principles. And now when one looks at when the person exits the fund through retirement, they will say, look, when you retire, you can actually purchase an annuity, either within the fund. In other words, you can use your 2/3 to purchase an annuity within the fund, wherein you are going to be paid those pensions. Or you can purchase an annuity out of the fund. You can have a living annuity and a life annuity. I don't want to get into the differences between the two, because they will take us the long day. But it's safe to say that with one, when you die, you can your benefits can actually be taken to your children with a living annuity. With a life annuity, when you die, it's like the insurance company takes everything, because the thing is, if you live for longer and you have small money, you can actually be paid for longer. So that risk, that benefit comes with a risk. But I don't want to get into those things. Let's just take it and deal with living annuities. Because those are the ones that have really caused a stir in practice. Now, in relation to living annuities, what happens normally is when a person retires, and the living annuities, the law around it is regulated by the Income Tax Act.
Okay.
You find the definition of the living annuity in the Income Tax Act. And that definition is important because that is the legislative framework within which living annuities are done in South Africa. It's not properly regulated at all. Insurance companies are doing their thing. Life is going on with them, and they are benefiting a lot from it in any event. Now, what is important to note is when you leave your fund through retirement only, you are then allowed to purchase a living annuity. A living annuity is an insurance product. It's not a pension fund. It is an insurance product that is purchased through pension fund benefits.
Yeah.
I hope that makes sense. It is an insurance benefit. It's not a pension benefit. So when you purchase a living annuity with one of the big companies, the arrangement there will be, look, I'm giving you this money, invest it for me, give me payment of 10,000 a month for as long as the money is there. Invest it regularly. Let's see how long it can take me. So you are able to draw income from that particular insurance product, but you are not eligible to get the full amount back. That is actually invested on your behalf. Like for example, if you gave them 500,000, you cannot after 2 weeks or after 2 months of getting your 10,000 say no, actually I want my money back. So the contract ties you into that thing that look, you are not entitled to receive the capital amount. You are only entitled to an annuity.
Yeah.
So that is important. Now the challenge in relation to divorces is this: for people who are married in community of property, at the time when the member retires, at that time, that means the pension benefit that the member is due to receive accrues to the member's estate in terms of the definition of the pension interest. It is a pension that he gets, it accrues to him. That means by accruing to him, whether it has been paid to him or not, by accruing I mean he is eligible to claim it. So the fact that he is eligible to claim it, that means it has accrued to his estate and it is deemed to be part of his estate. Actually, it is part of his estate. So now, the fact that it's part of his estate, that means it should be part of the joint estate. Now, it should be part of the joint estate. But now what happens is he uses the rules of the pension fund that allows him to purchase a living annuity. Then without consulting the member spouse, he goes on to purchase the living annuity. By purchasing a living annuity, he takes the money out of the joint estate and immediately prevents the non-member spouse from actually getting access to that money. And as soon as it becomes an insurance product, that means he's the only one who's eligible to it.
Wow.
So when you divorce and you claim your pension interest, the defense would be simply that, no, it's a living annuity, it's not part of the joint estate. Now, your rights at the time it accrued are not taken into account. The court, unfortunately, most of the judges have been utterly lazy to really think through the implication of matrimonial law in this interaction between pension law and insurance law. So they have not introduced matrimonial law into it to the disadvantage of non-member spouses. When you look at the Matrimonial Property Act, there is a provision there, section 15, subsection 2C, that entitles the non-member spouse to be consulted in a written form. There must be a written consent when any of the financial assets are taken out of the joint estate. But the rules of pension funds are structured in such a way that there is no consent. As the member of the fund, I can just invest in a living annuity and life will go on. Unfortunately, our courts have not taken this into account. We are still looking for clients with these kind of issues so that we can actually test the waters, so that we can develop the law. What has happened is, in relation to those who have been married out of community of property, but with the application of the accrual system. Because, remember, with the application of the accrual system, the person who is part of that marriage is not like the one in marriage in community of property. What happens normally is, at the time the member exits the fund, if these people are still married, the non-member spouse does not have any interest in that asset, because the interest only comes at the time of divorce. I'm not sure. Tumi, are you there?
I'm here. I can. You are flowing. I think it's just a bit of a delay.
You might find that at the time when the member exits the fund, the marriage is still fine. Everything is still fine. The non-member spouse does not have a ground to say, I need to be consulted, because there's no provision that says a person who's married out of community of property with the application of the accrual must be consulted. So that is important. So at that time, most of the people who are married with an accrual system, which most people think is the best, at that time they get really cheated. So it is important. It is really important that you understand those parameters. So we have had a number of cases that have came in relation to this thing when we are dealing with the accrual system. And the latest one is Montari case in the Supreme Court of Appeal, which also did not entertain, for some reason, the judgment was written by the president of that court, President Maya. What happened in that case was people were married out of community of property, and the non-member spouse claimed what she thought was a pension interest, which was now part of the living annuity. Right. And you find that at the time of divorce, then the guy claimed that, look, this is an insurance policy. You cannot claim from this thing. Your rights are not protected. That's fine. It went from the High Court to the Supreme Court of Appeal. When it got there, Maya P did something quite interesting. She invited matrimonial law. She went back to the earlier cases. She said, look, ordinarily the member in terms of family, in terms of matrimonial law will have this right and that right and that right. Yeah. But she did not investigate the rights, if any, of the non-member spouse at the time when the member exited the fund. She accepted that, look, this thing, when it is part of the living annuity, you cannot claim it. It's an insurance policy. But then she did something which I'm still struggling to understand. And some of the people that I'm coming up with, I'm grappling with that. What she did then is, she said, no, we cannot leave the non-member spouse without a remedy. In actual fact, all the future annuities that would be derived from the living annuity, the non-member spouse will be entitled to get something from them. Well, in law, it's very difficult to understand how. But this is not the time to be academic about these things. But that's what the law is. I saw somebody saying that we should be reminded that the law is not only for the defendants. Quite right. The thing is, what we are saying is very much objective in relation to both parties. So it will depend as an attorney which side you are representing, and you will have to think this through adequately. But the thing is, what we are doing is just to state where the issues are, so that we can really think through them as when we are representing. Because look, like I said, for the defendants or the respondents, as you put it, when somebody claims a pension, you are going to say, no, this is an insurance policy. That's the defense. That is just the defense. So the debate is kind of like, it balances itself out. So that is the challenge in relation to pension interests and living annuities. Before we go to the questions to me, I just want to deal with the issue of maintenance.
Yes, it came up actually as part of the question.
Now, in relation to maintenance, Section 37D of the Pension Funds Act, actually Section 37D generally, it deals with deductions. In other words, allowable deductions from pension benefits. In other words, those benefits that can be deducted when the member receives their pension fund benefits, or when the pension benefits are actually still held by the fund and they have not yet accrued to the member. Pension interest is one of them. There are quite several. Sometimes we have, for those people who are doing labor law, the money that the employer suffers as a result of the negligence or conduct of the employee, also that can be taken from the pension fund. So it's one of the deductions. One of these deductions is maintenance obligations. So in other words, when you have exhausted all the avenues, you have claimed maintenance from this court to that court, and the person says, I don't have the money to pay this and that and that. What you can do is to go back to the maintenance court, get an order that endorses the fact that you can actually be paid your what is owing from the maintenance obligations from the pension benefits of the person, notwithstanding the fact that the actual benefit has not yet been due to him. Once the fund gets a maintenance order, the fund will pay that amount that has been stated there.
And I think that's actually important, Clement, because our sisters are really suffering and struggling. And as I said last time, it's us men, right, who are not doing well, who are not coming to the party and helping. And this information in relation to that aspect becomes key and needs to be known and shared, so that maintenance defaulters or people who come up with these excuses are dealt with properly. And at the end of the day, we have kids being taken care of, because it's unfair, really, where people are living lavishly, but they're not taking care of home. So I think that option is quite important. But what it also means, you need to have someone who understands how you can achieve that, right? In terms of the law and stuff, because at times the advice at the maintenance court sometimes goes haywire. So you really need someone who can advise you properly to get there.
Unfortunately, this is one of those technical aspects of this area of law. Here, you won't go right with somebody who's taking chances. Because the thing is, that person, when he goes to the maintenance court for the first time, he will try to get these pension benefits. It won't happen. It won't happen because it has to be done as a measure of last resort. And there are technicalities that goes with it. Now, here you need somebody who really understands their law quite well in relation to these issues. Yes, we can take questions to me.
Yeah. So one of the things that came out was, what are some of the negotiating factors that can lead to a 50-50 split, for example, in relation to, I think we're talking about those benefits when you address Ndaba versus Ndaba. So remember what you said, it's not a foregone conclusion where even if that amount or benefit or asset vests, you have to, it's a process of negotiation and stuff. But what would be something that one considers as part of a potential 50-50 split? And related to that, are you able to buy out another spouse, for example,
Yeah, let me start with the last question. Yes, you can always buy somebody out, and buying somebody out, I'm using it quite functionally because it's all in the process of negotiation. It depends on how you negotiate your way through these things. Because sometimes one can say, look, you can take the house and you don't claim from my pension benefit, so that you waive your right to claim from my pension benefit. So that's one of the ways of buying somebody out. Or somebody can say, look, you take these two expensive cars and you don't get anything from my pension benefit. In most instances, when the two parties have pension benefit, they can say, look, there's no need for you to make a claim on mine and I also claim on yours. But sometimes you find that the other one is extensive and the other one is quite small. What will happen is the other one can say, look, you can claim from my pension benefit and get whatever, but I remain the owner of the house. So it depends on how you negotiate. So you can use that to buy somebody else out. But you cannot buy somebody else with their money. You cannot take the money that is in the bank, that's part of the joint estate, and try to use that money and say, look, I'll give you 500,000. Don't know. That 500 is part of his or her money. So you cannot use that. The question is, can you then go and take a loan? You cannot burden the estate with debts as well before you, unless you are saying post the divorce, this is what you are going to do. A lot of people do that, especially with houses. Somebody will say, look, I want to remain in the house, but I want to buy you out. And post the divorce, I will bond the house, take a loan, give you 250,000, and I remain the sole owner of the house, and I will deal with the bond payment. So it depends on the circumstances, but definitely you can always buy somebody out from whatever asset of the estate.
Thanks. Usizo Sito is asking, what swift action can a non-member take when the members resign upon receiving a divorce?
This is an important question which does not have a solution in South African law. A member is entitled, but to some extent it's fraud. It's just that it's not treated as such. It's fraud. Most people do this when they are about to when they are contemplating divorce. They resign so they can cash in and make sure. But again, once they want to cash in immediately so that they can divert the funds. Because when you cash in and you put it in the bank and we have records and all those things, what we can do is we can we can attach the property, the money at the bank, and it can be part of joint estate. It will be stupid. You'll be able to get whatever money that you get. But what most people do is they cash in and they divert the funds. So you may not necessarily get to access them. What currently happens is because now the only exit event that will entitle the member to get a portion of pension interest is actually the divorce itself. So before that divorce is given, you find that the non-member spouse is powerless. What normally people do will sign or will write letters to pension funds and say, we are involved in this thing, don't pay now. But the pension funds, they don't have a standing in law to prevent payment. There's no provision in law to do that. Even worse, what people do is, during the marriage, one of the parties resigns or is retrenched or dismissed or retires and gets the benefit and shares the benefit, enjoys them with the other person.
Yeah.
Now you find that, or maybe he uses the money alone. He doesn't share with the person. He uses the money alone. He does whatever he does with it. You don't see a cent of it. At the time of divorce, you are still working and everything is fine. Now you need to share your money with this person. Notwithstanding the fact that in real terms, you did not share, because the law looks at it this way. It says, when this person got his money, that money accrued to the joint estate. Therefore, you shared it. So that's how the law looks at it. But practically, you find that people really, they don't share all these things. So you find that it's a little bit unfair. With that as well, you find that there's no solution, and the law is a mess. There's another question that is interesting to me. Can you please explain the link between the clean break principle with regards, I don't know where that question went, with regards to the retirement fund benefits upon divorce? That's a
before you do, 1857 at exactly the hour instantly.
Yes,
we have just transitioned for your Q&A, and we'll do it in 10 minutes. So I'm going to save this on IGTV. Please do join us for just some of these questions so that we don't lose this type of discussion. So Clement, 10 minutes, we join in. Let me just save this.
No problem at all.
And thanks to everyone who's tuned in. I mean, if you aren't able to join the Q&A, we will understand. We're just going to spend 10 minutes or so just doing the Q&A. Thanks once again. Please go. No. Switch off. Switch off, yes. Yes. Hey guys, welcome. Thanks for joining. I have a guest who wants to be part of these sessions. There we go. Yeah, no, the whispering is everything. Yeah. As if I mood. Rar.
Abud.
Yeah. I know, I can hear you. Yeah. All right, we have over 25 people already. I think we can start. Yes,
the question that we received.
Sorry, Kaizer Chiefs, Sundowns, but let's continue. Yeah, no, but I think it's still early, so let's remain hopeful. The last question really, and welcome everyone, and we do appreciate you joining. Usually I always get interested when when we do the Q&A, the number of people, even more, still come in and join. It just really, for me, shows that people are interested. They want to impart knowledge and learn and engage, amongst other things. So to people who are laughing at our Kaizer Chiefs, it's not funny business, but it's football after all. Let's remain hopeful. But we can start on the clean break principle. I think that was the last question that came. And if you have other questions, please just post them on the live feed so that we can see that and empower others as well.
Thank you very much, to me. With the clean break principle, perhaps maybe I should give some context in relation to this clean break principle. The concept of pension interest in South Africa came when the South African Law Reform, as it was then, now South African Law Reform Commission, it was tasked with investigating how inequalities can be addressed in relation to women at the time who got a raw deal, were married, men were working, women were taking care of the family. And when they divorced, the man took the money and said, I've been working hard myself. So it was one of the ways of saying, look, at the time of divorce, women should get something out.
100%.
So what happened was, hence, the commission recommended these deeming provisions, that the pension interest should be deemed to be an asset because it is not ordinarily an asset.
Yeah.
But what we have seen from 1986, 1989, there were amendments to the Divorce Act, and all the provisions that we spoke about, were included in the Act.
Yeah.
From 1989 to 2007, this sharing of pension interest and the way in which it was done, it was only in relation to those retirement funds which were regulated by the Pension Funds Act. In other words, those members of those funds were able to get their pension funds immediately at some point. Because initially they had to wait up until the person retires and all those things. So there was a way in which, in 2007, the changes were made in relation to the pension funds that are regulated by the Pension Funds Act. That said, when you retire or when you exit the fund, at that time, through divorce, the non-member spouse can get immediately his or her portion of the pension interest. They don't have to wait for years for you to exit the fund. Yeah, so that was the clean break principle. So at that time, you break clean from each other. Your whatever obligations that you have, you make sure that you get whatever you want to claim, you claim it, you move on with life. That was the most important thing. Now, that was not applicable to other retirement funds that are regulated by other pension funds acts. So you found that in 2009, 10, a lot of cases were taken to the Constitutional Court, where the constitutionality of this discrimination was dealt with. Vesey case and Ngwewu case, they normalized things. They directed Parliament to amend legislation to ensure that the clean break principle is applicable across the board. In other words, the law as we know it today, when you divorce, at the time when you divorce, as a non-member spouse, you are entitled to claim whatever portion that has been stated in the divorce decree immediately after the divorce. That is the clean break principle.
Thank you. I know we are and properly so. I have actually the interpretation. Any other questions? We're happy to take those. Someone says, what if the non-member spouse refuses to work during the marriage, quits every job, you carry them through unwillingly, now they want a portion of everything? Can you contest this, I assume, at divorce?
Look, in actual fact, there's no need to contest it. You can actually try to prevent them from sharing. Remember last week or last week, we dealt with a remedy, a common law remedy, which has been codified, forfeiture of patrimonial benefits. You can actually use forfeiture to claim that, look, this person has his or her conduct, it is such that it led to the breakdown of the marriage because does not want to work and all those things. So you can use that as one of the factors that you can use to claim your forfeiture. But you cannot prevent them or contest their right to claim. You know, they will be entitled, but there is something that you can do. As whether you'll be successful, that's a topic for another day.
Yeah. No, thanks, Clement. It answers that, and it's quite interesting because I think sometimes in relationships, people, especially where it's at the stage where people want out, they frustrate the hell out of each other, and you it's very emotional and emotive at the time. Hence, all these options suddenly get out of the window, and that's why it's important to consult an attorney, right, and lawyer up in these type of instances, amongst other things. I don't see any other questions, Clement, from people, but perhaps you can just do a high-level conclusion, and we can close it out.
Yes, I mean, in conclusion, it is important, and I want to reiterate this, family law is one of those disrespected areas of law by a lot of attorneys out there.
Yeah.
And I'm saying that with all respect, because I've been involved in some of the matters that I'm dealing with now, post-divorce litigation. And it's not nice to deal with that, Like, for instance, yesterday I took instructions from a client. When I looked at the particulars of claim, it's one of those do it yourself, but she was assisted by, you can see there was legal drafting there. There's somebody who knows how to draft or who came across drafting. You got things like safe to admit. When you see those things, you know that there was a lawyer involved here,
Yeah.
But the work that was done was not adequate, but not because the person was incompetent, but because the person is not a four with the subject matter.
Correct.
So it is, look, there is no generalist in law. There's no one who knows everything. This view that there is this general practitioner, that is absolute nonsense. There's no one who is a general practitioner. No one is a general practitioner. All of us are specializing, even those who are not aware that they are specializing. We are actually specializing. We have a question here from Tibiso M. Now, this one is just testing us. Is the Divorce Act being amended to allow claims for pension interest in respect of deferred pensioners? No, my man. Deferred issues have been dealt with long time ago. Remember the Kruger case. Now I'm talking to him directly because I know exactly that he knows what I'm talking about. So remember the Kruger case dealt with the issue of deferred pensioners, and of course the amendment that were made in 2007 in effect reversed the decision of the Supreme Court of Appeal. And it made sure that it takes them as normal pension funds, and one can actually claim from the pension funds as you would do from the provident fund, from the pension fund, and perhaps maybe even the preservation fund. I do not really want to go to the deferred pension fund things because they are quite intricate. But I mean, Tibiso, you're out of order.
You've been called to order, Makabo. So it yourself.
Makabo is out of order.
But it's a question nonetheless. We have, I think I'll tell you now. Sitogos is you had asked a very interesting question. I don't know if you want to repeat it just before we ended the initial discussion. But for now, Clement, we really don't have much, and you were just concluding there in terms of how this type of law need not be disrespected. And I totally agree with you. And it's very interesting, right, that although people don't see it as important, it actually is, because at that time when you are looking out for your interest and you're divorcing or you want to protect your interest, you'll definitely need a family lawyer. And you would also need one that knows his or her work. And that's when you will then start realizing that, by the way, this is real stuff, because you'll be shortchanged. You will most likely not even get anything out of it if you have the likes of Clement as an opponent, and you find yourself wanting. So this is an interesting thing. You need to start thinking about it and saying, how do I as I continue now, start protecting myself, what is it that I can do to get my affairs in order and stuff.
To me, let me take this time to thank you for allowing me into your space and in your platform. And I'm happy that you are saving this thing in your IGTV so people can have access to them, and they can actually look and actually check them out, you know. And it's very easy in family law to fact check things. And please, everything that I've said, you can actually fact check it. It's very easy to do that. But I'm really pleased that we were able to do this marathon series, and I certainly hope that it really assisted a lot of people. And of course, for those people who really want like tailor-made solutions for their specific issues, I'm more than available to assist. And of course, Tumi will give out my details, and you can actually contact him for the details. I don't mind at all to really assist. Family law is not about fighting. Family law is not about litigation. Family law is not about going to court. Family law is about the lawyer to not be part of the emotive roller coaster between the parties, but to help them to reconcile, to help them to really meet each other, because every divorce can be settled. Every divorce can be settled. Some is just that they take time before they are settled. Some after 5 years, after 7 years, and they get to a point where they could have gotten to within 3 months. So it is really important that things are done properly. Yes, where there is a need to go to court, we do go to court, but we try by our level best to settle these things, because there are children involved sometimes, and you don't want to break relationships and then affect children. You don't want to do that. You want to repair relationships. Even look, when people cannot stand each other, cannot live with each other, that's fine. People part ways, get somebody that you can live with. But for the sake of children, you need to make sure that you get along. So it is really important to know that family lawyers, certainly let me speak for myself. I don't believe in litigation at all. But when it comes to litigation, I do litigation, and I litigate very hard. But I don't believe in litigation at all. I believe in settlements, and settlement can be reached, because also they are cost effective. They can really be affordable. But over and above that, thank you very much for allowing me into your platform, and I hope this will really assist your audience.
Thank you so much, Clement. And also, we will put this also on YouTube. Please subscribe, tell a friend. The handle is still the same one that I use on Twitter and Instagram. And it's the only way for us to be empowered. Share it in your WhatsApps, in your communities. People now have access to data. They can listen. As Clement had also pointed out, you know, this is empowering, this is knowledge sharing, but there are specific instances where you definitely need an attorney and you need to consult, and situations really differ in most instances. But once again, I also don't take lightly of your time, your data, and I learned a lot throughout this family law series this month in particular. And thanks to you, Clement, really dedicating, preparing, coming here and empowering this knowledge. I really do hope that when we do September, we will still have this type of rich content. I know I'm still going to have you in some of these sessions and other things that people are approaching me on, and we will really be doing more work. And thank you guys for watching. It's time to watch Kaizer Chiefs and
yeah, go and enjoy and pay, Baba. But thank you very much.
Thanks a lot, guys. Yeah, I'll save it here and then also on YouTube. We'll share it on the social media handles. Cheers, everyone. Thank you. Thanks. Thanks, Mr. Makapane. We appreciate it. I have to call you actually. I want us to run something similar on employment law with specific themes. Let's do it. Let's empower people, and let's really do what we can. Thank you very much, guys. We appreciate it. We appreciate your time. And cheers. Let me go and watch Kaizer Chiefs and grab one again. Cheers, guys.